By my report, we are not satisfied by the votes returned by ANIC in Adamawa State, including the votes scored by the first petitioner. I say so because I am not satisfied by irregular votes recorded in Adamawa State. That is why I sought the deduction of those votes. By my report, the petitioners won the election in 12 states. By my figures, I am not satisfied with the score for PDP in those states because they are printed with irregularities. I'm also aware that Labour Party also won the election in 12 states. In all the states won by Labour Party, I have also called for the deduction of those votes. I was in the situation room of the PDP on the day of the election. I have seen the report for Kano State in Exhibit PAH2. Furthermore, in response to the cross-examination of the Learned Senior Counsel for the third respondent, Fabian SN, the PW21 said, "It is true that I have been following ANEC activities since 1999. There was a time that ANEC chairman said the results for the 2023 election will be transmitted electronically and real time. I did not hear the ANEC chairman announce 2 days to the election that due to security and cash crunch, elections will not be possible to transmit the results as promised. The inspection of the electoral documents was carried out in the presence of agents of PDP. I did not make copies of those documents. I was assisted in my assignment by a number of people. Each of these people played a role. I stated the role played by each of those persons. I have seen volume 3 of my report. The said volume 3 of my report deals with ANEC documents which were not signed or stamped. I did not indicate which of them were not signed or stamped. I have seen the table in paragraph 11.2 of my witness statement. Only 26 states are mentioned therein. In my report on the electoral documents not signed or stamped, I mentioned 28 states. I stated that I analyzed the electoral documents from 36 states. It is true that my candidate's votes cannot be deducted more than once in a unit. I did not conduct extraction of the BVAS report. I am aware that BVAS machine was used for accreditation. I am the only one who signed the report because I was the team leader. I worked in all the states where alteration took place, including states where PDP won. That's the treatment of PW21 under cross-examination. It is tried in our law that cross-examination is a formidable tool for the demolition of the case of the opponent. The purpose of cross-examination is to discredit the witness called by the adversary. In the recent case of PDP and others versus Muhammad and others, Supra, the Supreme Court held that the primary object of cross-examination is to contradict the evidence of the opponent's witness in order to weaken his case. It is best resorted to in order to test the veracity of the witness. It has in the instant case been clearly established that by cross-examination, the PW1 testimony has lost esteem and value. A close look at the reports, Exhibit PAH1 to PAH3, will indicate that the witness was talking of 5,270 polling units, wherein he claimed that Form EC8A series were altered and were not signed. It also talked of 15,002 polling units, where Form EC8As were not stamped and signed. Yet all that is contained in the report are figures and data of these forms. None of the physical forms was exhibited in the report or tendered separately by any of the witnesses. In that situation, it is very difficult for the court to ascertain the truth of the allegation that several forms EC8A series had a lot of alterations and that they were not signed by the presiding officers. The law particularly requires that the presiding officers must sign the results. Signing Form EC8A is subscribing to the authenticity of the results. Where there is allegation that the forms were not signed, it must be clearly proved by the petitioners. The result forms must be presented in court for the court to verify lack of signature, stamp, and any alteration on the forms. Since PW21, who authored Exhibits PH3 and PAH4, did not place this in his report, and the petitioners did not call any of the polling unit agents to testify and place the forms before the court, to give vent to the allegation of alteration and non-signing of the Form EC8S for the 5,270 polling units listed in Exhibit PAH2 and the Form EC8S not signed, stamped for the 15,002 polling units in Exhibit PAH3. That allegation is unfounded and not proved as required by the law. On petitioner allegation, the first offender fails to collect the election results using the electronic collation system. The petitioners have not been able to prove that the Electoral Act or the guidelines made it mandatory for electronic collation system. I have carefully considered the submissions of parties on this issue of non-compliance with the provisions of the Electoral Act and the paragraphs of the regulations and guidelines for the conduct of election 2022. The Independent National Electoral Commission, INEC, the first respondent herein, is established by Section 153F1F of the Constitution, and part of its functions, as stated in paragraph 15, item F, part 1 of that schedule to the said Constitution, is to organize, undertake, and supervise elections, including election to the offices of the President and Vice President, among other political offices listed. Being a creation of the Constitution, INEC is empowered by Section 161 of the Constitution to make its own rules or otherwise regulate its own procedure, and in so doing, it shall not be under the control of the President. Indeed, by Section 158(1) of the Constitution, INEC shall not be subject to direction or control of any authority or person. By Section 4 of the 1999 Constitution, the legislative powers of the Federal Republic of Nigeria is vested in the National Assembly, which in the exercise of that power has enacted the Electoral Act 2022 to regulate the conduct of elections in the federal, state, and area councils of the Federal Capital Territory. Section 47(2) of the Electoral Act, relied upon by the petitioners, mandates every presiding officer to use a smart card reader or any other technological device that may be prescribed by the Commission for the accreditation of voters to verify, confirm, or authenticate the particulars of the intending voter in the manner prescribed by the Commission. Also, under Section 65 of the Act, the presiding officer shall transfer the results of the election, including the total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. Section 62(1) of the Act specifically provides that after the recording and announcement of the result, the presiding officer shall deliver same along with election materials under security and accompanied by the candidates or their agents where available to such person as may be prescribed by the Commission. Further, Section 64(4) tells that a collation officer or return officer at an election shall collate and announce the results of an election subject to his or her verification and confirmation that A, number of accredited voters stated on the collected results are correct and consistent with the number of accredited voters recorded and transmitted directly from polling units under Section 47(2) of the Act, and B, the votes stated on the collected results are correct and consistent with the votes or results recorded and transmitted directly from the polling units under Section 64. At this stage, it should be noted that Section 47(2) referred to in Section 64(4)(a) relates to procedure for accreditation of voters by the presiding officer using the technological device prescribed by the Commission. As for Section 64, referred to in Section 64, subparagraph 4b of the Act, it only mandates the presiding officer to count and announce the result at the polling unit. In fact, subsection 5 or Section 60 goes ahead to mandate the presiding officer to transfer the result, including total number of accredited voters and the results of the ballot, in a manner as prescribed by the Commission. The Act also provides in Section 60, subsection 5, that the collation officer or return officer shall use the number of accredited voters recorded and transmitted directly from polling units under Section 47, subsection 2 of the Act, and the votes or results recorded and transmitted directly from polling units under Section 64 of the Act to collect and announce the result of an election if a collected result at his or her lower level of collation is not correct. From the aforementioned sections, it is clear that while subsection 4 of Section 64 provides for what the collation or returning officer will use to verify and collect the results, Subsection 5 also provides for what the collation or return officer will use to collect the results. Subsection 6 of the same section provides for what the collation or return officer will use to determine the correctness of disputed results where there is a dispute. These are the original of the disputed collected result for each polling unit where the election is disputed, which in our view means the physical or hard copy of the disputed collected result. B, the technological device used for accreditation of voters in each polling unit where the election is disputed. C, the data of accreditation recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 47, Sub 2 of this Act. And D, the votes and results of the election recorded and transmitted directly from each polling unit where the election is disputed as prescribed under Section 60, Subsection 4 of the Act, which requires only the accounting and announcement of results at the polling unit. A careful examination of the above sections relied upon by the petitioners show that the Electoral Act had used the words deliver in Section 61, transfer in Section 65, and transmitted directly in Section 50, Sub 2, 64, Sub 4, 5, and 6 of the Electoral Act in stating how results of election should be handled under those provisions. A look at the definitions of those words in the Black Law Dictionary 6th edition show that the word transfer is defined at page 1497 as to convey or remove from one place or person to another, or to pass or hand over from one to another, or to specifically change over the possession or control. The word transmit, on the other hand, is defined by the same law dictionary to mean to send or transfer from one person or place to another, or to communicate. In my view, the Electoral Act 2022 has used the words deliver, transfer, and transmitted directly interchangeably to describe how the results of the election shall be moved from one stage to another until the results are finally collected and declared. In all this, the Electoral Act 2022 has not specifically provided that the results of the election shall be electronically transmitted. It is in the exercise of its powers under Section 160, Subsection 1 of the 1999 Constitution, and Section 148 of the Electoral Act 2022 that that the first respondent herein made the regulations and guidelines for the conduct of elections 2022, as well as ANIC Manual for Election Officials 2023. In paragraphs 14A and 18A of the regulations, the first respondent prescribed the bimodal voter accreditation system, BVAS, as the technological device for the purpose of accreditation and verification of voters in the 2023 general elections. The petitioners have also hinged their allegation on non-compliance on paragraph 38(1), Roman 1 and 2, 48A, B and C, 50, Roman 5, 7 and 20, 51, Roman 2, 54, Roman 12, and 55, Roman 12, and 93 of the regulations and guidelines. Paragraph 38, those provisions refers to have been reproduced in this judgment. So from the foregoing provisions of the regulations and guidelines relied upon by the petitioners, it is clearly evident to me that although the Electoral Act has provided in Section 621 for the delivery by the presiding officer of the result, along with other election materials under security and accompanied by candidates or their polling agents, were available to such persons as may prescribed by the first respondent. The first respondent has, by paragraph 30 of the regulations and guidelines quoted above, introduced electronic transmission to a collation system in addition to the physical transfer of the election results to the registration area for vote collation officer. As stated earlier, the technological device prescribed by ANIC in the conduct of the 2023 election is the bimodal voter accreditation system. The functions of BVAS, as stated in paragraph 14A and 18A, is for verifying the voter through a positive identification of the voter and authentication of the voter by matching his or his fingerprints or face, that's facial recognition, thus accrediting the voter to vote at the election. and storing the data and number of such accredited voters. By paragraph 38, Roman 2 and 3 of the regulations, the BVAS is also to be used by the presiding officer to upload a scanned copy of the EC8A to the annual result viewing portal, after which the presiding officer shall take the BVAS and the original copy of each of the forms to the registration area for ward collation center. From the above functions of the BVAS, it is clear to me that apart from using the BVAS to scan the physical copy of the polling unit result and upload same to the result viewing portal area, there is nothing in the regulation to show that the BVAS was meant to be used to electronically transmit or transfer the results of the polling unit direct to the collection system. It should be noted that ANEC results viewing portal, RF, is not a collection system. Thus, the Supreme Court in Electoral and ANEC has explained the difference between the collection system and RF, where again JSC held as follows. As their names depict, the collection system and the ANEC result viewing portal are part of the election process and play particular roles in that process. The collection system is made of the centers where results are collected at various stages of the election. So, the polling unit's results transmitted to the collection system provides the relevant collection officer the means to verify a polling unit result as the need arises for the purpose of collection. The result transmitted to the result viewing portal is to give the public at large the opportunity to view the polling unit results at the election day, close of court. A community reading of the relevant provisions of the Electoral Act 2022, the regulations and guidelines for the conduct of election 2022, and the ANEC Manual for Election Officials 2023 show that the Electoral Act expressly provides in Section 621 that after recording an announcement of the result, the presiding official shall deliver same along with election materials and the security and accompanied by the candidates or their polling agents to such persons as may be prescribed by the Commission. The regulations and guidelines as well as the ANEC Manual also state that hard copies of election results shall be used for collation, and it is only where such hard copies of the election results exist. No such hard copy of the election results exists, that electronically transmitted results or results from the ANEC will be used to collect the results. I had earlier said that the non-compliance that can significantly affect the result of an election must be such that is substantial enough to cause the court to invalidate it as prescribed by Section 135 of the Electoral Act. The burden and standard of proof is primarily on the petitioners to establish the existence of those facts or allegations asserted by them. It is important to note here that although election petitions are sui generis, they are governed by the Evidence Act as well. Where therefore an election petition is founded on allegations of non-compliance, as in the instance case, from the myriad of decisions, the onus is directly on the petitioners not only to establish such through credible and compelling evidence, they have to go further and demonstrate through credible evidence that the non-compliance was substantial and that the non-compliance truly affected the results of the election to warrant their being annulled. See Akinlade and another versus ANEC, Audu and ANEC, Oke versus Mimiko, Kente and Ishaku, Nda Kene and Adamu and others. The Electoral Act made provision for declaration of results and the posting of results of the election. This is Section 66 and 68 of the Act, which have been produced in this judgment. By the law, results are declared by the counting of votes cast in the election and in accordance with the constitutional provision for the election of the president as in Section 133 and 134 of the Constitution. The votes so counted and collected are the votes cast at the polling units. Let me underline here that the conduct of an election, in the conduct of an election, certain processes must have been worked over to conclude and confirm that the election was conclusive. The steps outlined by the law must not be broken. These steps are accreditation, conduct of polls, counting of votes, collation and announcement of results, signing of result forms, and publication of results. The results sought by the reliefs sought by the petitioners are declaratory in nature. It is cited a law that where a petitioner seeks declaratory reliefs, the burden is on him to establish his claim. His success is on the strength of his own case and not on the weakness of the defense of the respondents or defendants. See Omissionary and Arebeshola and Oga versus Piazzo. It is also the law that the pleading and the claim of the petitioners determines the burden and the standard of proof that is required. By Section 135 of the Evidence Act 2011, if the commission of a crime by a party to any proceeding is directly an issue in any proceeding, civil or criminal, it must be proved beyond reasonable doubt. See the application of this provision in the cases of PDP and IG versus PDP and others, APC and another versus Obaseki and others, Suleiman and others versus APC and others. In all these cases, the position of our law is that whenever crime is alleged, even if the case is a civil case, its proof must be that of beyond reasonable doubt. In the instant case, the petitioners have grounds of non-compliance with the Electoral Act 2022 and allegation of corrupt practices. Section 134(1)(b) refers to the ground of corrupt practice or non-compliance. If the ground pursued in any petition is simply non-compliance with the Act and there is no tincture of allegation of crime, the proof required would be on the balance of probabilities. But the standard of proof in any ground that is primarily on corrupt practices would require proof beyond reasonable doubt that allegation being criminal in nature. In the instant case, and on the issues being resolved here, the petitioners tendered some documentary evidence directly from the bar. The objections to the admissibility of most of the documents had earlier been dealt with by this court in the earlier ruling on the objections as to the admissibility of the documents, and some of them have been held inadmissible in evidence. The petitioners called two star witnesses alongside other witnesses. The star witnesses are PW19, Dr. Alex Adum Tar, and PW22, Senator Dino Melai. The sworn evidence on oath of PW19 is at pages 131 to 160 of the petition. In paragraph 23 and 30 of his sworn deposition, Dr. Tar, that's PW19, said as follows: I know that on the face of the form EC8D, 8 in A in bracket, there are calculation errors as shown and contained in the report of the statisticians, which the petitioners shall rely upon. The non-compliance consists of refusal to authenticate all the intending voters in the election using the technological electronic device prescribed by the first respondent, in addition to failure of the first respondent to transfer the outcome of the election directly into the portal of the first respondent, created for the viewing of the public as a means to ensure the integrity of the elections at the polling unit, and the electronical collation system before the declaration as to who is the winner of the election. There are no particulars supplied in his statement on oath. All that can be read from this statement are predictions without substance. When he was cross-examined by A.B. Mahmoud SN, he said that it is true that I am a lawyer and politician. I am the national coordinator for the petitioners. I was at the National Collation Center. I was throughout okay, it's up to here. Well, the cross-examination of that witness has been reproduced. It's a bit the sworn deposition on oath of the next star witness of the petitioners, PW22, Senator Delo Melai, is almost a rehash of the entire petition. What he said on cross-examination by A.B. Mahmoud has also been reproduced. The testimonies of these star witnesses under cross-examination aggregated the same account given by other witnesses that the election went well. Accreditation with the Vivas device was all right. The agents of the petitioners were on ground at the polling units, and that the results were entered on forms EC8As and duplicate copies given to the agents. The facts elicited from the cross-examination of these witnesses have belied much of the strands of their written statements on oath. This, of course, is a challenge to the credibility of the evidence of PW19 and PW22. While cross-examination has the capacity to tarnish the credibility of a witness, it also has the corresponding capacity of strengthening the case of the opponent. In the instant case, the evidence elicited from the PW19 and 22 on cross-examination has fortified, in my opinion, the case of the respondents that there was nothing wrong with the results of the 2023 presidential election and that there was substantial compliance with the Electoral Act 2022. That also played out in the cross-examination of PW20, Olatunji Oshele. His deposition on oath is at page 204 to 207 of the petition. That is the same trend in the account of these witnesses. They were majorly giving account of not only the polling stations they voted, but other places not within their reach. The significant tone is that they testified of casting their votes without any problem. The results by their admission were properly declared and taken to the vote collation centers. The irony though is that the witnesses, is it okay? The irony, though, is that the witnesses did testify to a peaceful and valid election in their polling units where they voted and then turned around to give evidence of alleged infractions in polling units where they were not present. Their testimonies in that respect are hearsay. Hearsay evidence is not admissible and has no value in proving the petition filed by the petitioners. Furthermore, in the instant petition, first respondent consistently maintained that the technical glitch that occurred on the election day was the failure of the e-transmission server to upload polling unit results for the presidential election into the IRF portal. It claimed that the glitch only prevented the members of the public from viewing or assessing the results that were already uploaded and listed on the first respondent e-transmission system. On their part, the petitioners asserted in their petition that the glitch claimed by the first respondent was actually a bypass by the first respondent to tilt and switch the results of the presidential election in favor of the second and third respondents, as pleaded in paragraph 40. In furtherance of that assertion, they also pleaded in paragraph 41 and 42 of the petition as follows. The petitioners applied to the court for subpoena to issue to the witnesses listed in paragraphs 41 and 42 of the petition on 26/5/2023. These witnesses were not called by the petitioners, and no reason was given as to why they backed down from calling the witnesses they pleaded to call in proof of their petition. It is tried that litigation, particularly election dispute litigation, is fought on pleadings. Parties swim or sink with their pleadings. For this, see the case of Anyafulu and others versus Mecca and others. See also Ifeanyichukwu Osondu Company Limited and another versus Ahibe. Those pleadings in paragraph 41 and 42 of the petition having been abandoned are discountenanced. In the same vein, paragraph 96 of the petition averts that agents of the second and third respondent disrupted the election. Votes scored were not accurately recorded, and the ballot papers were torn. The petitioners avert that video recording shall be tendered. However, the video recording was not tendered in that regard. In this respect, the presumption in Section 167D of the Evidence Act 2011 that they withheld the said video recording because it will be against them if tendered shall also apply. From the foregoing, therefore, it is very clear and certain that the petitioners have failed to prove that the 2023 presidential election and return of the second respondent was invalidated by reason of corrupt practices or non-compliance with the Electoral Act 2022. This issue, that's issue 1, is therefore resolved in favor of the respondents and against the petitioner. Issue 2 is whether the second respondent was lawfully declared and returned as the winner of the presidential election held on 25th day of February 2023, he having not secured one quarter of the total valid votes cast in the Federal Capital Territory, Abuja. This issue has been resolved in petition number 3, and we adopt our finding and conclusion in that regard in this petition. What? Issue 3 is whether second respondent was not disqualified under the provisions of the Constitution of the Federal Republic of Nigeria 1999 as amended to contest the presidential election held on 25th February 2023, having regard to the alleged order of forfeiture arising from drug-related offense, his acquisition of the citizenship of the country other than Nigeria, and presenting a forged certificate to the first respondent. I do not intend to reopen this issue, having already ruled on it while considering the preliminary objections of the respondents. I held therein that the petitioners did not plead facts in support of non-qualification or disqualification of the second respondent in their petition, and their efforts to remedy it through their replies to respondents' replies were belated and of no avail. That ruling constitutes issue estoppel, binding not only on the parties, but on this court, meaning that this court cannot depart from the earlier ruling. So this issue is therefore discontinuous. This issue is whether the second respondent was elected by majority of lawful votes cast in the, that's issue 4, yes. This issue is whether second respondent was elected by majority of lawful votes cast in the election, and first respondent was right in declaring him as elected. This issue covers ground 3 of the petition. The facts in support of this ground were pleaded by the petitioners from paragraphs 105 to 145 of the petition. The petitioners specifically pleaded in paragraph 106 to 107 as follows. The petitioners shall lead evidence at the hearing to show that A, the result of the election as announced by the first respondent, and especially the votes allocated to the second respondent, do not represent the lawful valid votes cast at the election. And B, the lawful votes cast at the election were deliberately and massively deducted from the first petitioner's scores by the first respondent in order to return the second respondent, 17. The petitioner shall give evidence to show the election results as purportedly declared by the first respondent in respect of each state of the Federation, including the Federal Capital Territory, the details of which are contained in the table following are wrong. The table referred to by the petitioners is the table of results declared by the first respondent. There is no other set of results placed before this court by the petitioners to form the basis of our finding of fact as to whether the declared result is wrong or not. Success or failure in an election depends on figures, which is in turn dependent on votes garnered by each candidate. So where the complaint in an election petition is that candidate returned did not poll majority or highest votes in the election to be returned as contended herein by the petitioners. Not only must the figures disputed be pleaded, the figures or votes the petitioner perceives as the correct figures of the election ought to be and must also be pleaded. That is not only logical. Support for it can be found in several decisions, among them Nadabo versus Dabai, where Okoro Jesse, as he then was said, when a petitioner is alleging that the respondent was not elected by majority of lawful votes, he ought to plead and prove the votes cast at the various polling stations, the votes illegally accredited to the winner, and the votes which ought to have been deducted from the supposed winner in order to see if it will affect the result of the election. Where this is not done, it will be difficult for the court to address the issue. See Awolo and Shagari, close of court. See also Ojo versus Isohe and others, Taba Jesse as he then was. The averments of petitioners in paragraph 107 of petition only showed the votes declared by ANEC, which the petitioners are disputing as manipulated. Nowhere in the petition did petitioners plead that what they considered the authentic votes of the election to guide the court in the inquiry suggested by them in this allegation. The second respondent did not poll majority of lawful votes in the election. Their petition, therefore, did not meet the legal threshold to ignite a proper inquiry by this court, and so lame even on the pleadings. Going further, if we must at all, the petitioner claim is that 19,702 polling units results contains various forms of infractions. They assert that results from a total of 4,307 polling units are without stamp on the respective forms EC8A from the states, and details are said to be in the statistician's report, which report we have repeatedly held incompetent and inadmissible. They also contended that results from 1,300 polling units do not have signatures of the presiding officers on the respective forms EC8A. It was also alleged that results from 6,408 polling units have and indicate zero accreditation. It was further alleged that 9,464 polling units across 30 states showed that the votes returned are in excess of accredited voters. Furthermore, that the presiding officers failed to properly fill and countersign alterations in election forms, including forms EC8A, EC8B, EC8C, and EC8D in over 40,000 polling units, which they claimed were in the statistician's report. It is clear from the averments in the petition as captured above that neither the particulars of the polling units in issue nor those involved in the irregularities were given by the petitioners. In any case, our law is well settled that before a party can legally rely on fraud or forgery or any form of malpractice as alleged in this petition, the facts must not only be pleaded but particulars thereof must be provided in the pleadings. The petitioners in the pleadings from paragraphs 128 to 142 avert to issues of violence and disruptive activities. These allegations are criminal in nature. The standard of proof where an allegation of crime is made in an election petition is proved beyond reasonable doubt and not on the balance of probabilities. See Emmanuel and Umana. A complaint of massive suppression, deduction, and allocation of votes connotes forgery or fraud. particulars of which must be pleaded and proved beyond reasonable doubt. See Kaki and PDP and others, Ngobodo versus Ono. First, respondent joined issues with the petitioners' allegations in paragraphs 92 to 142 of the petition. The second respondent and the third respondent, in a similar manner, joined issues with the petitioners in calling on them to prove their claims as required by law. What this entails is that the petitioners who made all these allegations have the burden to prove all their allegations as required by law. The petitioners have placed reliance on the evidence of their statistician and forensic expert, who are PW21 and PW26 respectively. Had time to look at the evidence of these witnesses and had ruled that their evidence, apart from being improperly before the court, is also hearsay. The statistician's report rolled out figures or forms which he claimed were either not signed or stamped, but none of the forms referred to was attached to the report. The polling unit agents of the petitioners, who were present in all the polling units around the country, were not called to testify to any problem or difficulties in their polling units on the 25th day of February 2023 presidential election. That is fatal to the petitioner's case. Thus, in Belgore versus Ahmed, it was said by Taba JSC as follows in the lead judgment. With respect to the volume of documentary evidence, I wish to state at the risk of repetition that they were merely tendered across the bar by Land Council for the petitioners at the trial. He did not and was not in a position to answer questions or otherwise speak on any of them. Their makers were not called. In such circumstances, was the trial tribunal bound to ascribe probative value to them? I shall answer this question in the negative. The trial tribunal had no duty to accord probative value to the mass of documents, their status as certified documents notwithstanding. There is no doubt that the petitioner's decision to tender the mass of documentary evidence at the trial was prompted by the urgency dictated by Section 285(6) of the 1999 Constitution as amended. That, however, does not diminish the petitioner or appellant's burden and standard of proof of the petition. They had a duty to prove their petition according to law, close of court. This position of the law may have been fairly watered down under the current electoral regime by Section 137 of the Electoral Act 2022, stating that it shall not be necessary for a party who alleges non-compliance with the provisions of this Act for the conduct of elections to call oral evidence if originals or certified true copies manifestly disclose the non-compliance alleged. But even at that, it cannot be gainsaid that oral evidence is necessary to explain discrepancies in original or certified true copies of election documents, where the complaint verges on whether an alteration or amendment in an original or certified true copy of a polling unit result was made with intent to falsifying it, or whether it was simply made to correct an apparent human error in the course of making entries in the result. Such situation would surely need a witness to explain or speak to the documents in order to prove falsification or election documents when it is so alleged, as pointed out in Belgole and Ahmed. See also the case of Waziri Ibrahim and Shagari and Buhari versus Obasanjo. All the above, in my view, also explain the rationale for the employment of the adverb manifestly by the draftsman in Section 137 of the Electoral Act 2022. What the word suggests is that the non-compliance complained of must be apparent on the face of the electoral document. It must not be something that can be explained away by oral evidence one way or the other. I have in this judgment explained the issues of evidence of witnesses who were not polling unit agents. The collection agents of the parties who testified were given accounts of stories related to them by people who were not called as witnesses in this petition. The interpretation of Section 137 of the Electoral Act 2022 by the petitioners was generously and swiftly silenced, the otherwise potent adverbial word manifestly used by the legislature in that section of the law. Manifestly is defined by online dictionary to mean in a way that can be readily seen by the eye or understanding, with the understanding plainly or obviously, evidently close, of course. This means for the petitioners to throw up their arms and say we need not call oral evidence in proving non-compliance as they are conversing. The certified copies of documents presented must be manifestly and readily seen to convey the fact of non-compliance. We have started this Electoral and ANEC for the JSC. From this authority, it is the law that where the documents tendered and relied upon by the petitioners do not manifestly disclose the non-compliance alleged, the petitioners will still need to call witnesses who witness the alleged acts of non-compliance to testify. In the instant case, the petitioners tendered loads of certified copies of the document. The petitioners filed 5 schedules of documents. The first schedule was filed on 30th May 2023. The second was 31st May 2023. The third was 2nd June 2023. The fourth was 7th June 2023. And the fifth was filed on 21st June 2023. From these schedules of documents, a lot of exhibits were generated and tendered. These exhibits were objected to by the respondents. I had earlier in this judgment dealt with the documents and objections. However, I want to have a look at these documents to see if they manifestly show any lack of compliance. These exhibits include the following: exhibits PG, PG1 to PG3, which were the printouts of bimodal voter accreditation system, VIVAS, for Abia, Adamawa, Akwa Ibom, Anambra, Bauchi, Bayelsa, Benue, Borno, Cross River, Delta, Ebonyi, Edo, Ekiti, Enugu, FCT, Abuja, Gombe, Imo, Jigawa, Kaduna, Kano, Katsina, Kebbi, Kogi, Kwara, Lagos, Nasarawa, Niger, Ogun, Ondo, Oshun, Oyo Plateau, Rivers, Sokoto, Taraba, Yobe, and Zamfara were admitted, though objected to. Exhibit PH, PH1 to PH36, which were the ANEC data on number of registered voters and collected PVCs for the 2023 general elections for the state, listed in the first schedule of documents as numbers 46 to 82 were admitted. The second schedule of documents was filed on 31st May 2023, and the documents listed here Surprisingly, the documents were dumped on the court without any witness linking them up with the specific complaints of non-compliance. It is certain law that despite the tendering of exhibits in proof of a petition, the onus of proving the case pleaded and for which the documents were tendered in evidence lies on the petitioner. In the instant petition, a lot of documents were tendered from the bar. When a party decides to rely on documents to prove his case, there must be a link between the documents and the specific areas of the petition. The party must relate each document to the specific case for which the documents were tendered. Failure to link the documents is fatal and catastrophic, as it is in this case. The Supreme Court, in the recent case of Tumbi Bido versus ANEC, have started the portions. In this situation, it is invariably correct that all the allegations raised in this petition have not been proved as required by our law. See Buhari and ANEC, Part 12 JSC. It is also important to draw our minds to the fact that criminal allegations are usually and directly made personal. For allegations of crime to be proved against the respondents, it must be proved that they committed the corrupt acts or aided, abetted, consented to, or procured their commission. Furthermore, it must be proved that the corrupt practices substantially affected the outcome of the election. See Omishore versus Aribeshola. The law also places the onus on the petitioner to demonstrate by credible evidence that the alleged corrupt practice indeed occurred and that it affected substantially the outcome of the election. In that quest, the petitioners pleaded some states where the malpractice allegedly occurred. One of such states is Sokoto State. They placed PW19, PW21, and PW22 to prove the allegations that the first respondent cancelled results from 241 polling units in Sokoto State in respect of National Assembly elections in the state, but went ahead to declare results for the presidential election. The three witnesses, PW19, 21, and 22, were not in Sokoto during the election. There is also no evidence tendered of the cancellation of results in any of the units alleged. PW19 and PW22, when cross-examined, said they were in Kogi State, where they voted, and later came to Abuja. The PW21 is the statistician who testified of overvoting, non-signing, and cancellation of forms used, but he did not tender or show those compromised forms. The same occurred in their testimonies in Kano State, Kogi State, Lagos State, and River State. From the foregoing consideration, it is very clear that there was no credible evidence by the petitioners to prove the allegations of corrupt practices. Under this issue raised, the petitioners were asking if the first respondent was not wrong in returning the second respondent when he was not duly elected by majority of lawful votes cast in the election. From the facts placed before the court, the first respondent declared the results of the election by which the second respondent was returned. Section 1342 of the 1999 Constitution talks of the highest number of votes cast at the election if the contest was among more than two candidates, as in the instant case, not majority of votes cast as propounded by the petitioners. The first respondent was therefore right from the results declared by her, in the absence of any rival or alternative result placed before this court by the petitioners, that the second respondent, who scored 8,794,722 votes, as against 6,984,520 votes scored by the petitioners in the election, scored the highest number of lawful votes cast in the election. Issue 4 is accordingly resolved against the petitioners and in favor of the respondents. Having resolved all the votes, four issues against the petitioners, I find that the petitioners have successfully proved any of the grounds as laid out in paragraph 16 of their petition. It is my conclusion that this petition also lacks merit. Having considered and decided that the three petitions, number CA/PEPC 03/2023, CA/PEPC 04/2023, and CA/PEPC 05/2023 are all devoid of merit, the petitions are hereby dismissed. Accordingly, I affirm the declaration and return of Bola Ahmed Tinubu by the Independent National Electoral Commission Annex as the duly elected President of the Federal Republic of Nigeria. The parties in the three petitions are to bear their respective costs. So now I will call on my learned brother by immediate right to read his own judgment.
Thank you. Please sit down, sit down. Thank you, my Lord. privilege and privy to be part of the decision and the judgment elaborately given by my Lord presiding Honorable Justice Haruna Somani, and I am in full agreement with the lead judgment as delivered by him in these three consolidated petitions, which are petitions number CAPC 03-2023 and CAPC 04-2023 and CAPPC 05-2023. I agree also with the consolidated rulings on the various objections and other interlocutory applications relating to the competence of witnesses and the documents tendered in the three petitions highlighted. I also agreed with the reasoning and the conclusions arrived at the rulings on the preliminary objections and the substantial issues raised therein. In any concluded election, there are bound to be a winner and losers. While the winner celebrates victory, an aggrieved loser may come before the court to ventilate his grievances. This is made possible by the Constitution of the Federal Republic of Nigeria, 1999 as amended, which in Section 6 thereof empowers the courts to determine disputes, including election disputes. It is well settled that an election petition by nature is sui generis, of its own kind or class. It is not like going to court to make a claim of debt, contract, or tort. It has its own character, and it is unique by its nature. The slightest non-compliance with a procedural step, which otherwise could either be cured or waived in ordinary civil proceedings, could result in a fatal consequence to election petition. A lot of authorities listed there. Election petition as a special proceeding is specifically regulated by the Constitution of the Federal Republic of Nigeria, the Electoral Act, and other rules of procedure, such as the Federal High Court Civil Procedure Rules, the practice direction of the Honorable President of the Court of Appeal for the hearing of the election petition and for the hearing of election petition and the election petition appeals. By Section 285(5) of the Constitution, an election petition shall be filed within 21 days after the date of the declaration of results of the election. By Section 285(6) thereof, an election tribunal shall deliver its judgments in writing within 180 days. These timelines are sacrosanct and cannot be extended by the court. It is tried law that under the first schedule, under the first schedule of the Electoral Act, the election petition to be filed is well regulated. Paragraph 4, 5, and 6 of the Electoral Act provides that election petition shall be accompanied by a list of witnesses that the petitioner intends to call in proof of the petition. 2, written statements on oath of witnesses. 3, copies or lists of every document to be relied on at the hearing of the petition. A petition which fails to comply with subparagraph 5 shall not be accepted for filing by the Secretary. An election petition which does not comply with subparagraph 1 or any provision of that subparagraph is defective and may be struck out by the tribunal or the court. The word shall, used in this legislation, makes it mandatory for a petitioner to comply with the provision of the law in pursuing or prosecuting election petition. Failure to comply is fatal. Election petitions are fought on pleadings, competent and credible witnesses. Where a petition is deficient in pleadings and evidence, it is difficult to say it is proved, or that it is difficult to prove the same petition. In the instant case, the petitioner's pleadings were deficient. While they complained of non-compliance with the Electoral Act against first respondent, their own petitions were massively deficient in non-compliance with the said act. The lead judgment has elaborately dealt with these issues. When a court is called upon to determine an election dispute, he is called upon to do justice. Our notion of justice is doing justice is not that of doing justice according to the whims and caprices of the judges or the parties. It must be justice according to law. Justice according to law is also that which is neither based on technicality nor justice according to the suggestive clout of pressure groups, but as such as it substantially meets the demands of justice. This, with all respect, is what we have done in the lead judgment. I therefore concur with the leading judgment that these three consolidated petitions, having not been proved, are hereby dismissed. I abide by the consequential orders as made in the lead judgment.
I will call on my land brother, my immediate left, to deliver his own judgment.
I have read the lead rulings and judgments of my learned brother, H.S. Samani JCA, in the above consolidated petitions. I agree with his reasoning and conclusion in each petition and adopt same as mine. I add a few words for emphasis. Petition number 3. Ground 1 of the petition is that the respondent was, at the time of the election, not qualified to contest the election. The first complaint under this ground is that the purported sponsorship of the second and third respondents by the fourth respondent was rendered invalid by reason of the third respondent knowingly allowing himself to be nominated as the first vice presidential candidate, whilst he was still a senatorial candidate for the Borno Central constituency. The controversy about the third respondent knowingly allowing himself to be nominated in more than one constituency was the subject matter in PDP against INEC and others, reported in 2023 LPELR 60457 SC. The Supreme Court, Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, in their concurring opinions, held that the third respondent, having withdrawn his nomination and personally delivered the notice of withdrawal to his party, fourth respondent in this petition, on 6 July 2022, he was no longer a candidate for Borno Central constituency senatorial election. In his subsequent nomination as the vice president for the presidential election was not multiple nomination. The opinion of the Supreme Court of the Supreme Court, Paukoro JSC, Augi JSC, Ogumiju JSC, and Ajim JSC, is not a comment or observation made in passing. It is an exposition of the law on withdrawal of a candidate from an election and the allegation that the third respondent knowingly allowed himself to be nominated as the vice presidential candidate while he was still a senatorial candidate for Borno Central constituency. Concurring opinion forms part of the lead judgment, and it is meant to complement him by way of addition or an improvement on the issues resolved in the lead judgment. See Unwana against FCDA, Oloruntoba Oju against Abdurrahim, and both and others against Just Electricity Distribution Company, PSC. Citations supplied. The Supreme Court, having rendered its considered and definite opinion on the validity of the nomination of the second respondent as vice presidential candidates of the fourth respondent, attempts to reopen the issue in this court is a misadventure. The second complaint is that the second respondent was at the time of the election not qualified to contest for the office of the president, as he was fined the sum of $460,000 for an offense involving dishonesty, namely narcotics trafficking, by the United States District Court, Northern District of Illinois, Eastern Division, in case number 93C 4483 on 4th October 1993. The contention of the learned counsel for the petitioners is that the order of forfeiture made by the court is a fine under Section 137(1)(d) of the 1999 Constitution of the Federal Republic of Nigeria. It is a settled principle of interpretation that when the words used in the provisions of the Constitution are clear and unambiguous, same must be given their plain and ordinary meaning, unless to do so will lead to absurdity. See Abegundi and other cases cited here. The context in which the word sentence is used in Section 137(1)(d) of the Constitution connotes formal pronouncement awarding punishment after conviction for an offense. Conviction is a finding of guilt after an indictment, arraignment, and trial. See Kole also against FRN Mohammed against Olawumi, Modu against Federal Republic of Nigeria. Therefore, the words sentence, imprisonment, and fine used in Section 137(1)(d) of the Constitution definitely connotes only a punishment imposed on a defendant following an indictment, trial, and conviction for an offense. See Babangida Usman against the state. Citation supplied at 40 to 41. Sharif against Federal Republic of Nigeria. Citation supplied. In civil forfeiture or a non-conviction-based forfeiture proceedings, in civil forfeiture or non-conviction-based forfeiture proceedings, the government only needs to show by preponderance of evidence that the property is a proceed of crime or was used to facilitate a crime. Criminal forfeiture, on the other hand, is seizure of a property connected with a crime after obtaining conviction and as part of sentence or punishment for the crime. Civil forfeiture is not a conviction or verdict of guilt after an indictment, trial, and conviction. See Jonathan against Federal Republic of Nigeria, citation supplied, where the Supreme Court per Karas JSC considered the provisions of Section 17 of the Advance Fee Fraud and Other Related Offences Act and persuaded by the decisions of the various courts across the world, held that civil forfeiture is an action in rem embarked upon when the interest of the government is merely to recover the proceeds of unlawful activity. The court also held that an application for interim forfeiture of property that is not predicated on conviction of the owner of the property would necessarily be an action in rem, because it is the recovery of the property that the law aims at. A forfeiture order by a foreign court can only be accepted and recognized by a court in Nigeria for the purpose of Section 137(1)(d) of the Constitution if it is made after an indictment, trial, and conviction, and properly proved as required by Section 49 of the Evidence Act. In addition, the conviction and sentence must be shown to have been a product of due process of law. Compliance with the process of law has to be determined by the procedure and standard set by Section 36, subsection 5 and 6 of our Constitution. The forfeiture order being relied on by the petitioners has not been shown to be a result of a process similar to the one set by our Constitution for a trial of a defendant for an offense. The Appellant Counsel relied on Austin against United States, citation supplied, and Teams against Indiana, decided on 20 February 2019. The forfeiture proceedings in the two cases were instituted as part of criminal proceedings after conviction of the defendants. Secondly, forfeiture was regarded as punishment for the purpose of protecting the constitutional rights of the defendants against imposition or infliction of excessive bail or excessive fines or cruel and unusual punishment for an offense. Eighth Amendment provides that excessive bail shall not be required, nor excessive fines imposed, nor cruel or unusual punishments inflicted. In United States against usury, 1996, other citations supplied, the United States Supreme Court considered the relationship between punishment and civil forfeiture. The court held that in rem civil property forfeiture did not constitute a punishment such as fine for purposes of double jeopardy clause of the Fifth Amendment. In Abacha against Federal Republic of Nigeria, citation supplied, forfeiture was also defined in the context of the doctrine of double jeopardy. The appellant contended that the state could not indict and prosecute him for the offenses of conspiracy, receiving stolen property, dishonestly and concealing stolen money after forfeiting the properties listed under forfeiture of assets, etc., certain persons decree number 53 of 1999. The rejection of the plea of double jeopardy means that the court did not consider the forfeiture under the forfeiture of assets, etc., certain persons decree number 53 of 1999 as punishment. From all the above, it is clear that a non-conviction-based forfeiture, being civil in nature and an action in rem, can in no way be equated with a sentence of imprisonment or fine imposed for an offense involving dishonesty or fraud or for any other offense to disqualify a person from contesting for election to the office of the President of Nigeria. An indictment, arraignment, trial, and conviction are necessary preconditions for disqualification of a person under Section 137(1)(d) of the Constitution. Ground 2 of the petition is that the election of the second respondent was invalid by reason of corrupt practices or non-compliance with the provisions of the Electoral Act. The allegations are basically predicated upon electronic transmission of the election. A global reading of the Electoral Act 2002, particularly sections 47(2), 61(5), 62(1), 65(1)-8, will show that what the Act provides for is manual transfer and manual collation of results by collation officers at various physical collation centers. There is no provision for electronic transmission or IREF or electronic collation of results in the Act. By paragraphs 38 and 48A of INEC Regulations and Guidelines for the Conduct of Elections 2022, the first respondent made provision for electronic transmission and physical stroke manual transfer of election results from the polling unit. However, paragraph 48C provides that if no result has been electronically transmitted from the polling unit, the provision of paragraph 93 shall be applied. Paragraph 92 categorically provide that at every level of collation, where INEC copy of collated results from the immediate lower level of collation exists, it shall be adopted for collation. By paragraph 93, where INEC hard copy and electronically transmitted results from the immediate lower level of collation do not exist, the collation officials shall use duplicate hard copies issued to the Nigerian police force and agents of political party to collate results. It is therefore not correct that it shall not be possible to collate results of the election where results have not been electronically transmitted. By law, the INEC Regulations and Guidelines for the Conduct of Elections 2022 is subordinate to the Electoral Act, where a provision of the guidelines conflicts with the Act. The Act prevails. See Odeneye against Efunuga, Yesom against Pisasai, citation supplied. Section 134(2) of the Act. By Section 134(2) of the Act, any circular, press release, promise, or stated intention of INEC that is in conflict with or expand the provisions of the Electoral Act cannot prevail over the Act. INEC guidelines cannot be elevated above the provisions of the Electoral Act so as to elevate electronic transmission of results over and above manual and physical transmission of hard copies and manual collation of results as prescribed as provided for by the Act, to the extent that non-compliance with the regulation automatically invalidates an election. PW4, the professor of mathematics, presented to this court as an expert witness, confirmed under cross-examination that IREF is not a collation system. He also confirmed that whether or not transmission to IREF failed or the image of result on the IREF is blurred will not change the result entered onto Form ECATA at the polling unit level. Under cross-examination, PW12 stated that petitioners had 133,000 agents. He was not a party agent at any of the INEC designated polling units or collation centers. None of the 133,000 party agents was called to testify that there was a dispute regarding any collated result at any polling unit, registration stroke ward, local government, state or national collation centers. So as to enable the collation officers at the various levels of collation to activate the process prescribed under Section 64, subsection 6 of the Act. PW 12 stated that the petitioners believed they have won the election if the results had been uploaded. When asked about the score of the petitioners by which they claimed to have won the election, he answered rhetorically that how are they supposed to know the score when the result was still being uploaded on the IREF? So, this petition is about the belief of the petitioners that they will have won the election if the results had been uploaded on the IREF. Election petition is a serious issue. A petitioner is not permitted to engage in fishing expedition or a roving inquiry, as the petitioners herein did. It is clear from the pleadings and the evidence of PW 12 that the petitioners were from the onset engaged in a wild goose chase and inquisitorial adventure. By paragraph 9 of the regulation, a political party has a right to appoint one person as its polling agent for each polling unit, collation center, and one representative at each point of distribution of electoral materials in the constituency where it is sponsoring candidates or candidates for an election. According to PW 12, the petitioners exercised that right and had 133,000 party agents in the election. I stated earlier that none of those 133,000 polling agents was called, and not a single one of results forms collected by any of the agents was tendered in evidence. Electoral Acts provided a candidate who wishes to challenge any result declared by INEC with a potent material, which are the forms on which results are entered, signed by the first respondent officials and party agents, and a duplicate copy of it is given to the party agent. Any serious candidate ought not to depend on INEC for materials to prosecute his petition. By Section 167D of the Evidence Act, the failure of the petitioners to produce election result forms collected by their agents raises a presumption that if those forms had been produced, it would have been unfavorable to the petitioners. The first respondents in their pleadings and evidence through DW1 stated that the delay in uploading the results from the polling units to the IREF was due to a technical glitch which occurred on their transmission system, which was rectified within a few hours. All that the petitioners could do was to bring a PW1, a member of the second petitioner, who claimed to be a software engineer and an employee of Amazon. She had the temerity and the audacity to claim authorship of a document, a word of which does not belong to her. The first respondent never claimed that the glitch occurred on Amazon Web Services. It is obvious from PW7's evidence that the petitioners did not understand the explanation of the first respondent, or were just fixated on their belief that they won the election without any cogent and credible evidence. And they did not even bother to place any such credible evidence before this court. Were they expecting the court to go and gather evidence from the street or from the market, or to be persuaded or intimidated by threats on social media? That is not the way of the court. See the admonition of Toby JSC in Buhari against Yaradua on a similar situation like the instant case, citation supplied. Thus, the petitioners not only failed to prove non-compliance with the Electoral Act, they failed to prove that the non-compliance substantially affected the result of the election declared by the first respondent. It is settled that even if non-compliance with the Electoral Act is established, If there is evidence that despite the non-compliance, the result of the election was not affected substantially, the petition must, as a matter of law, be dismissed. See Abubakar and others against Yaradua, citation supplied. The third ground of the petition is that the second respondent was not duly elected by majority of lawful votes cast at the election, having not obtained 25% of the votes in FCT. The provisions of the Constitution must be read together to discover the intention of the framers of the Constitution. A court of law has no power to take away or limit the words of the Constitution or import into it what it does not say. CLLU, Abib, and another. Against the Honorable Attorney General of the Federation, citation supplied. A narrow interpretation that would do violence to the provisions of the Constitution and fail to achieve the goals set by it must be avoided. Our Constitution is based on principles of freedom, equality, and justice in all ramifications, and is for the purpose of consolidating the unity of our people. Section 41 and 2 of this Constitution, 14(1) and 2, states that the Federal Republic of Nigeria shall be a state based on the principles of democracy and social justice. The participation by the people in their government shall be ensured in accordance with the provisions of the Constitution. The right to vote is at the foundation of our democracy. It is the most potent and priceless opportunity a citizen has to have a say in who governs. Every citizen who is qualified to vote must be afforded equal opportunity to cast his or her vote to elect leaders who governs. Our constitutional principles of freedom, equality, and justice, democracy, and social justice means that the vote of each citizen shall count. Each and every vote should count equally. No vote should weigh more than the other. The principles of equality of vote must be protected by the court. The interpretation of Section 134(2) of the Constitution, being urged on us by the petitioners, is an unjust manipulation of the Constitution to create inequality of votes. It negates the principle of equality and justice, democracy and social justice, and participation of the people in their government enshrined in our Constitution. It strikes at the very foundation of our Constitution. It is capable of further dividing the citizens of this country. The politicians are good at using all sorts of means and sentiments to divide the citizens of this country. The interpretation being urged on us is their latest invention in that regard, and unfortunately, they found a ready alliance with those who should know better. The interpretation being urged on us is squarely against the letters and spirit of our Constitution, and it is hereby rejected. Based on the above and the further reasons lucidly explained in the lead judgment, I too dismiss the petition. 04. I have had a preview of the reasons given in the lead judgment of my learned brother. I agreed with his reasoning and conclusion. I adopt same as mine. I hereby abide by the orders made therein. As for 05, I adopt my reasoning in respect of the third ground, and I also dismiss the petition. On the whole, I too dismiss each of the three consolidated petitions. I abide by the order made in respect of the petition in the lead judgment.
My learned brother, by my extreme right, shall present his own judgment.
Long last.
There's still one more?
It's not complete. You know. I'd earlier read in draft the rulings and judgments of my learned brother, Aruna Simon Samani, in these consolidated petition numbers CAPEPC 03, 04, and 05, 2023. I am in complete agreement with His Lordship's reasoning and conclusions on all of them. First, for petition numbers PEPC 04, 2023, that is the Allied People's Movement petition, I am of the very fixed view that the issues agitated by the petitioner therein concerning third respondents alleged disqualification by reason of matters connected to and surrounding his running mate's nomination and relinquishing of his earlier nomination by his party for the Borno Central Senatorial District having been settled on their merit by the Supreme Court in its judgment, in appeal numbers SCCV 501, 2023, in third and first respondents' favor therein, with the Apex Court even holding that the said issues did not disqualify them, that decision constitutes issue estoppel, being status defining, and so judgment in rem it binds every person, including non-parties to the suit, like the petitioner in petition number CAPC 04-2023, C. Kotun, and Oyekomi, Soson, and Odemuyiwa. Furthermore, by the doctrine of stare decisis, it also binds this court. In fact, it will, in my humble opinion, amount to judicial heresy for this court to involve itself in inquiring by whatever guise into that same issue already settled by the Apex Court. Coming to petition number CA03, 2020, of Peter Obi and another versus INEC and others, and CAPC 05, 2023, Atiku Abubakar and another, again, I am of the very fixed view that the two sets of petitioners did not by any means discharge the burden on them of proving that the results of the presidential election of 25th February 2023, as declared by first respondent, were incorrect. Incidentally, their burden is even made heavier by the legal presumption that the votes of an election declared by the official organizing body that INEC is are correct, and it is for the person asserting the contrary to prove it, Buhari and INEC, see Buhari and INEC. Even their resort to first respondent's failure to keep its initial promise to upload poly-unit results of that election to its result being portal IREV real-time, which failure the alleged evidences election manipulation, does not help them. And specifically on this allegation of manipulation of election results, the point must be made that since it is their case that from the word go that the election results in issue were manipulated by first respondent in favor of second respondent, and specifically that the manipulation took the form of, quote, programmed failure of the technological device, machines, that is beavers, by first respondent by intercepting the results, quarantining, warehousing, and filtering such results before releasing them to the IREF portal,